The agency disclosure statement is required under Ohio law to be included in real estate transactions at the time an offer to purchase is written. It is to be provided to the client or customer prior to entering into discussions about the offer itself. This is because the client could be put on notice as to who represents them before they divulge information that could be potentially used against them in the negotiation process. First, you must complete the top section of the form with a specific property address as well as the buyer's and seller's name. If either party is a trust, LLC, estate, or similar entity, you use the name of the entity as the name of the seller or buyer. However, when the form is executed, you will need to have the authorized party sign on behalf of the entity. This must remain consistent throughout all of your purchase paperwork. Section 1. This section refers to a transaction involving two agents from two separate brokerages. This is the most common type of transaction. In this case, simply fill out the blanks. Remember, another Keller Williams Market Center is considered a separate brokerage. We are all independently owned and operated with separate brokerage IDs. Section 2. This section refers to a transaction in which both agents involved are with the same brokerage. In this case, the brokerage is Keller Williams Greater Cleveland West. You will always use the first option in this section. Fill in each agent's name with the party that they represent. You will not ever use option 2 in this section, as we do not practice disclosed dual agency at the agent level. Section 3. This section refers to a transaction in which only one party is represented as a client and the other party is a customer. In the case of a for sale by owner, the seller might be a customer and the buyer might be your client. Conversely, if it's your listing, the seller is your client and the buyer would just be a customer. Once you have filled out the appropriate section for the transaction you are getting involved in, have your client or customer execute the document before you move forward with any other offer paperwork. Remember, if it is an entity that is the client, such as an LLC, trust, or estate, be sure to ask for verification that the person signing the documents is on record as the person authorized to acquire or dispose of the asset on behalf of the entity. If the person signing is utilizing a power of attorney for the buyer or seller, you must obtain a copy of the document and verify that it has been filed with the county and includes the verbiage allowing them to conduct business on behalf of the individual and that the POA allows for the disposal or acquisition of real estate. Bear in mind that this form has 2 pages. The back page explains dual agency, and although we don't practice dual agency at the agent level, you must understand that the brokers and managers of our market center do act as dual agents in transactions where the parties are both represented by Keller Williams Greater Cleveland West agents. Make sure your buyer initials the back page.